Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Welcome to Law and Chaos, where Texas Democrats have left the state to try and save democracy, and Donald Trump is willing to let every criminal in New Jersey go free rather than make Alina Habba take a real job. We've got a lot to cover, so let's get after it. Hey guys, I'm Andrew Torres, and you've probably noticed Liz Dye is not with us today. She is ill. We hope to have her back for Friday's show. If you want to send her well wishes, head on over to BlueSky. It is lizdye.bsky.social. With that in mind, let's do a quick docket alerts.
Docket alert!
I've got updates for you on 3 stories that we have written about lately. The first we wrote about at our Substack at lawandchaospod.com. That is a case captioned Perdomo versus Noam. It involves the detentive stops being made by ICE agents throughout Los Angeles, in which they are essentially racially profiling individuals, many of whom are citizens, sweeping them up often by agents who have no displayed identification on the basis of nothing more than, oh, you're at a Home Depot parking lot, you speak Spanish, you look like you are of Hispanic origin. And Judge Frimpong said, you may not do that. And the Trump administration immediately appealed that TRO to the Ninth Circuit and requested a stay. The Ninth Circuit did not stay Judge Frimpong's order. And actually what they did was strengthen that TRO. They did so by partially granting a stay. So procedurally, it looks a little strange, and there have been a lot of press stories that have treated it like it's a partial win. This is not a partial win. This is a complete vindication for the plaintiffs in Los Angeles. It is a complete victory so far with respect to requiring the Trump administration to follow the law, and the procedural mechanism that the Ninth Circuit used actually makes Judge Frimpong's order stronger. It stayed the effect of 5 words in her order. And if you want to get into all of that delightful procedural geekiness and read a good news story, head on over lawandchaospod.com. Okay. Second update, we have been laughing about Hunter Biden's defamation lawsuit against Overstock.com weirdo Patrick Byrne, mostly in the subscriber bonus because there's been some procedural weediness. Patrick Byrne managed to fire 5 lawyers in 3 days and brought in Stephanie Lambert. Yes, the same Stephanie Lambert who has 2 pending criminal charges against her. Yes, the same Stephanie Lambert who was kicked off of 1 case in the District of Columbia by a Trump appointee and denied the opportunity to join another one in Florida. That's Stephanie Lambert. So this case was supposed to go to trial in December of 2024. Thanks to Patrick Byrne's shenanigans, which include fleeing to Dubai, it has been postponed twice, and now it has been postponed a 3rd time to October of 2025. The trial judge in that case declined, at least at this point, to grant the ultimate sanction of defaulting Patrick Byrne. That was something that Hunter Biden's lawyers had asked for. And the judge said, no, I think this should go to trial. But I think we haven't heard the last of this case, and I think we haven't heard the last of sanctions. At least, I hope not. And third docket alert, we have developments in the Blake Lively, Justin Baldoni lawsuit. There is some great Civ Pro geekery about what it takes to maintain a privilege log. Did they comply? I can't wait to get into this. We also have the return of ChatGPT lawyering in the form of a motion to quash filed in a Nevada court by Perez Hilton. And wow, I did not know Perez Hilton was still a thing. He's still gross. Anyway, that story is also hilarious, and it would be massively unfair for me to cover it without Liz. So that's the end of Docket Alerts. I have two stories for you today. The big one, no surprise, is what's going on with Texas, where Democratic state legislators have decamped to Illinois and New York to try and stop a partisan gerrymander from going into effect. Is it legal? Will it work? I'm going to go through all of that with you. And then I've got a brief update on parking lot lawyer extraordinaire Alina Habba and how Trump's efforts to keep her on the job, a job that she is manifestly unqualified for and not legally entitled to hold, could wind up upending every criminal prosecution in the state going forward. So that's fun. And last bit, it is Tuesday. Ordinarily, we would thank our new supporters on Patreon and on Substack. We do appreciate it. We could not do the show without you. We don't have that list right now because Liz is the keeper of that list. So I promise you will get an extra special shout out this week. And if you'd like to join their ranks, you know how to do that. Just head on over patreon.com/lawandchaospod or sign up on our Substack, and you will get to skip, for example, this ad break that's coming, and you'll get to help us continue to do this show that we love. And we're back. So let's get into it. What is going on in the state of Texas? Well, it starts, as with so much on this show, with Donald Trump. Trump is about 10 points underwater in the polls, more in others. And the more voters are asked about specific policies, and Trump really has had two specific policies so far, immigration and tariffs, he's way underwater, 20, 30 points on those. The more, people hate him. Donald Trump knows that without outside help, he is going to lose. Republicans will lose the House of Representatives in the 2026 midterm elections. So Trump demanded that Republicans in red states, particularly in Texas, redraw their federal congressional maps in order to give him more seats. Trump said, very simple redrawing. We pick up 5 seats. And the Texas legislature responded with House Bill 4. We will link the bill and the map in the show notes. It gives Trump his 5 seats. Look, we have talked about how these gerrymandering bills work before. You feed the partisan data you want into a computer, and you tell it to crack and pack. So the crack is splitting, let's call them Democrats, who are geographically concentrated in one area and in eras past would have formed one congressional district across multiple congressional districts. So you could take 52% in a geographic area, make that 4 districts, each with 13% Democrats added in. You dilute the voting strength of geographically concentrated political opponents. And the pack is the opposite. That's where you take Democrats from across the state and you pack them all into a single district. So, Texas has 38 congressional districts. Those districts are split 25 to 13. That is roughly 2/3, 1/3. And I should point out, registered Democrats are 46.5% of registered voters in Texas. They actually outnumber Republicans, but if you assume every independent is also a Republican, Democrats are still way more than 1/3 of the state. And that's how it currently breaks down. Of those 13 Democratic seats, 11 are blue or blue-leaning seats. 2 belong to Democrats in districts that were won by Donald Trump in 2024. They are what you would call Republican-leaning swing districts. That includes Henry Cuellar, who is under federal indictment, and Vicente Gonzalez. HB4 would eliminate all the swing districts and would create a new map that is 30-8 Republican, giving Trump those 5 seats he demanded. Each one of those 30 Republican districts would be a Trump plus 10 district or better, again, using 2024 data. So if you just move the votes in from 2024, each and every one of those districts would have gone for Trump by 10 or more points. So they are 30 safe Republican seats. It would force 2 senior Texas Democrats, including Lloyd Doggett, who I would love to rabbit trail about with you guys someday, because Lloyd Doggett is an incredibly fascinating political candidate, but that's going to have to wait for another time. Anyway, it would stick 2 senior Democrats into a competition for a single seat in Central Texas. So look, brass tacks. Giving Trump 5 more seats is a huge swing for Democrats who are trying to retake the House in 2026. And, at some point, we should probably do a deep dive on whether House Bill 4 will stand. But for now, I'll summarize it like this. If it gets passed, the Roberts Court in 2019 legalized partisan gerrymandering. That was Rucho versus Common Cause. We have blasted that decision on this show and elsewhere for years. So the fact that House Bill 4 gives Republicans an unearned super duper majority is sadly not a good argument to oppose it in court. It's not going to win because the Roberts Court, once again, changed the rules. Now, Democratic lawmakers opposing HB4 have also said that if enacted, they will bring Voting Rights Act claims. That is too lengthy to digress on right here. I will just say that this is not a case at first blush where it is obvious that the map is invalid under the Voting Rights Act, and it's very complicated. So the bottom line is that I think there is significant anxiety on the part of Democrats that if HB4 passes, it will hold up in court, or at least it will hold up in court long enough to give Donald Trump the 5 seats he needs that might help him keep the House in 2026. So Democrats really, really do not want HB4 to pass. Republicans really do. So that takes us back to Texas, where on Saturday, the State House Select Committee on Redistricting voted 12-6 along party lines to advance HB4 out of committee, and they scheduled a floor vote for it at 3 p.m. on Monday as we were recording this show. Spoiler alert, that vote did not happen. The thought process was and is that if HB4 gets out to the full House for a floor vote, it will pass. Trump will get those seats. Democrats are outnumbered in the Texas State House 83-67, so they hold just under 45% of the 150 total seats. And I'm doing the math because we're about to talk about quorums. A quorum is the minimum number of individuals present that must be there in order for the body to conduct business. You have quorums in business, you have quorums in corporate governance, you have quorums at nonprofits, and you have quorums in the legislature. If you didn't have quorums in the legislature, it would be chaos, right? 2 legislators could sneak into the state house, gavel themselves into session, and start passing law, right? That's chaos. Now, in many contexts, a quorum is just a bare majority, right? 50% plus 1. So 150 members of the Texas legislature, a quorum would then be 50%, 75 plus 1, or 76. But Texas elected not to do it that way. They made a deliberate choice on purpose back in 1876. And as we'll discuss, they've had multiple opportunities to change this provision in the state constitution. It is Article 3, Section 10, and it is good law. It says, 2/3 of each house shall constitute a quorum to do business, but a smaller number may adjourn from day to day and compel the attendance of absent members in such manner and under such penalties as each house may provide. So again, back to the math, 150 members of the Texas House, 2/3 is 100. There must be 100 House members present for there to be a quorum. When at least 51 Democrats walked out, that meant there was no quorum. And if there is no quorum, then Rule 5, Section 8 of the Texas House rules kick in. And it says, until a quorum appears, Should the roll call fail to show one present, no business shall be transacted except to compel the attendance of absent members or to adjourn. So that's the strategic reason the Democrats walked out. They did not have the votes to stop HB4 from getting to the floor. They did not have the votes to block it from becoming law, but they did have enough votes to block a quorum. And if there isn't a quorum, then the House can only do one of two things. It can compel the attendance of absent members until there is a quorum, or it can adjourn and go home. So, at 3 p.m. today, the Texas House convened itself back into session, called the roll. There was not a quorum present. All that it can do is one of those two things. Now, Republicans have ratcheted the rhetoric up to, I was going to say 11, but really it's more like 78 on this, right? Attorney General Ken Paxton has called for the arrest of the Democrats who walked out. Here's what he said on X Twitter. I support the immediate arrest of these rogue lawmakers who have fled their duties. These radical Democrats are spitting in the face of every Texan they swore to represent. This is cowardice and dereliction of duty, and they should face the full force of the law without apology. Governor Greg Abbott said Democrats who walked out should be expelled from their offices. He said, this truancy ends now. The derelict Democrat House members must return to Texas and be in attendance when the House reconvenes at 3 p.m. on Monday, August 4th, 2025. They were not. For any member who fails to do so, I will invoke Texas Attorney General Opinion Number KP-0382 to remove the missing Democrats from membership in the Texas House. We're going to talk about that, but KP-0382 is Ken Paxton, right? So what Abbott is saying is, Ken Paxton, the same one who just howled about arresting Democrats, sent me a letter in 2021 that said, you can arrest Democrats. This has no legal force. The opinion is nonsense. But we're going to go through all of that. There is one more legal wrinkle that I want to talk about that sets the stage, and that is Governor Abbott, who very carefully, unlike Ken Paxton, did not accuse the Democrats of having committed a crime by walking out and breaking the quorum. But then he says this, in addition to abandoning their offices, these legislators may also have committed felonies. Many absentee Democrats are soliciting funds to evade the fines they will incur under House rules. Any Democrat who solicits, accepts, or agrees to accept such funds to assist in the violation of legislative duties or for purposes of skipping a vote may have violated bribery laws. See Texas Penal Code 3602. The same could be true for any other person who offers, confers, or agrees to confer such funds to fleeing Democratic House members. I will use my full extradition authority to demand the return to Texas of any potential out-of-state felons. So that really tees up, I think, three questions. The big one, number one, is what the Democrats are doing illegal, right? Or if not illegal, or you have a fair sense of where I'm going with that one. Does it break norms, right? Is this the kind of thing that we would be howling about if Republicans did it? Question number one. Question number two, what does it mean to compel the attendance of absent members? What can the Republicans do to bring the Democrats back? And then number three, is what the Democrats did going to work? Is it going to block HB4? And we will delve into each and every one of those questions after this brief ad break, unless, of course, you are a subscriber over at patreon.com/lawandchaospod or on our Substack at lawandchaospod.com, at which point no ads for you ever. And we're back. So let's start with the big one. Can Democrats, are they legally allowed to do this? Are they breaking the law? Are they felons? Are they flouting norms? And the answer is no. At most, what the Democrats are doing is breaking procedure. And far from being a break with norms, what the Democrats are doing is actually exactly what Texas intended. Before the break, I told you almost every state has the majority quorum rule, 50% plus one, but 4 states do not. 4 states have the same rule as Texas that says 2/3 majority requirement in order to have a quorum, in order for the legislature to meet and pass laws. That's Texas and also Oregon, Indiana, and Tennessee. And this is a deliberate choice by each of those 4 states. Here's why. If you just have a bare majority quorum rule, then whatever is the majority party in a 2-party system always gets its way, right? There's nothing that the minority party can do to stop a quorum from occurring. And to look at it when the shoe was on the other foot, let's talk about Oregon, where Republicans are in the minority, have been in the minority for a very long time. And you might not have known this, but Republicans in the state legislature in Oregon have walked out 6 times since 2019 in order to break the quorum and stop legislation. They have protested things like COVID-19 masking requirements, reproductive freedom bills, gun control bills, funding for education, and redistricting. And each time they successfully broke the quorum. Similarly, quorum breaking has a long history in Texas, right? The last time that Democrats tried it was in 2021, where Governor Abbott had convened a special session in order to cram through, among other things, voter suppression legislation, and the members, Democratic lawmakers, fled the state in order to prevent there from being a quorum. They stayed out of state for 38 days. Eventually, they had to return to the state. The governor called a second special session, and that bill passed. So far from being out of the norm or illegal or anything like that, this is a thing that is a feature, not a bug. It's a bit of an oddball feature in the state constitution. We could debate whether or not it should be in the Constitution. And I should add that in 2021, after the last Democratic walkout, Republican lawmakers attempted to pass SJR 1, which would have amended the Texas state constitution in order to eliminate that supermajority quorum requirement. That bill failed. So this is something that is well known. The Republican rhetoric is the Republican rhetoric in the era of Trump, but there is absolutely no basis to say that anything that Democrats are doing here is criminal. It is what Republicans have been doing in Oregon far more frequently and far more effectively. Now, let's go back to that Greg Abbott, Ken Paxton letter on which he's relying. This was an opinion letter issued by Texas Attorney General Ken Paxton in 2021 to a Republican member of the Texas state legislature who said, hey, can we kick these Democrats out of office if they leave the state in order to break a quorum? And Ken Paxton, this is being interpreted as saying yes, but I'm going to read a little bit from his rather lengthy opinion letter. And before I do that, I want to say again, this is an opinion letter. This is an opinion letter of one of the most extreme partisan Republicans in the country. This is an opinion letter of an extreme partisan Republican who is running for the Senate in Texas, right? Like this is barely worth the paper it's printed on. And what it says is not, if Democrats leave, they have vacated their office. What it says is, the Texas Supreme Court has long recognized that a vacancy made by resignation, death, expiration of the term of office, abandonment, removal, or forfeiture, and then proceeds to argue that abandonment is a resignation and that in describing abandonment of office, an intermediate Texas appellate court said, abandonment is a species of resignation. It is voluntary acts. The former is a formal relinquishment. The latter, abandonment, is relinquishment through non-use. Abandonment implies non-use, but non-use does not of itself constitute abandonment. The failure to perform the duties pertaining to the office must be with actual or imputed intention on the part of the officer to abandon and relinquish the office. The intention may be inferred from the acts and conduct of the party and is a question of fact. So essentially, what Paxton's memo says is there is a procedure to describe an office as being abandoned or vacant. Here is the standard. And then he says, if you wanted to go to court and make the argument that these legislators have abandoned their office, you can do so, right? He says, if a legislator is believed to have forfeited their office by abandonment, the attorney general or the county or district attorney of the proper county may initiate a suit in district court. If the court determines that the public officer has forfeited the office, the court shall enter judgment removing the person from office. If an officer is removed from office by court or other tribunal, a vacancy occurs on the date the judgment becomes final. So what Paxton says is, yeah, you can bring, it's called a quo warranto action. You can ask the court to determine whether they have vacated their offices. The standard is very high, right? It must be intentional relinquishment, and it doesn't occur immediately. So put all of that together. This is an awful lot of chest thumping about illegality, about truancy, about being felons. That's right. And that is not the case. Oh, and I suppose I should connect up the felon piece. For reasons that are about to become clear as we talk about the second question, the legislators had to leave the state, right? That is, they left from Texas largely to Illinois. Some of them went to New York. And in doing so, they are incurring fines of $500 per day. On a political level, there have been multiple groups that are interested in raising the funds to pay for those fines. Governor Abbott says, that sounds like bribery to me, and cited to the Texas Penal Code, Section 36.02. I will tell you, 36.02 is a bog standard bribery law. It says a person commits an offense if he intentionally or knowingly offers, confers, or agrees to confer, or, this would be for the legislators, solicits, accepts, or agrees to accept from another any benefit as consideration for the recipient's decision, opinion, recommendation, vote, or other exercise of discretion as a public servant, party official, or voter. And then it goes on. But this is, again, the standard framework for bribery. We have discussed on this show on many occasions. There's absolutely no way, I feel very confident in saying this, that you could bring a valid bribery charge, particularly when this occurred after the fact. And, oh, by the way, it was Ted Cruz who won the opinion from John Roberts that said, it's not bribery if you tip your legislator after the fact. Look, these guys fled the state first, and then there are offers being made by political parties and by political candidates to pay their fines. Part of that is because legislators are paid $600 a month. Being a state legislator in Texas is a part-time job. And these folks are not necessarily independently wealthy. $500 a day is a lot more than $600 per month. This is chest beating. There is no evidence right now that anybody has been bribed to leave the legislature. That this is just kind of nonsense. Okay. So that's the first question. Is this illegal? No. Is this norm breaking? No. But it does violate the procedure, and the Texas Constitution does say that the House can establish rules to bring absent lawmakers back. And that gets to question number 2, which is, what does that mean, right? And here's what it means. Here's where it comes from. Let's go back to the Texas Constitution. Article 3, Section 11 is the rules of procedure, punishment, or expulsion. And it says, each house may determine the rules of its own proceedings, punish members for disorderly conduct, and, with the consent of 2/3, expel a member, but not a second time for the same offense. So that says they get to set their own rules in terms of punishing members for disorderly conduct. And the previous section said that the House may set rules for requiring absent members to attend if they have broken a quorum. That comes from House Rule 5, Section 8, Securing a Quorum. And it says that when the call of the House is moved and seconded and ordered by majority vote, the main entrance to the hall and all other doors leading out of the hall shall be locked, and no member permitted to leave the House without the written permission of the Speaker. The names of members present shall be recorded. All absentees for whom no sufficient excuse is made may, by order of a majority of those present, and that is a majority of the Republicans remaining. Now, this is the one thing they can do in the absence of a quorum. be sent for and arrested wherever they may be found by the sergeant at arms or an officer appointed by the sergeant of arms for that purpose, and their attendants shall be secured and retained. The House shall determine on what conditions they shall be discharged. Members who appear voluntarily shall, unless the House otherwise directs, be immediately admitted to the hall of the House and shall report their names to the clerk to be entered in the journal as present. Now, that word arrest is a very weird word there because Article 3, Section 14 of the Texas Constitution says that senators and representatives shall, except in the cases of treason, felony, or breach of the peace, be privileged from arrest during the session of the legislature and in going to and returning from the same. So I don't believe that this is an arrest in the criminal sense of the word. That's why I said the answer to the question 1, is this illegal, is no. I think this is using the word arrest in a custodial sense, right? But nevertheless, it is clear, this has been contemplated since 1876, if you don't show up, the sergeant at arms can be sent out to track you down and haul you in and make you appear. And that's why the legislators are not just decamped out to a remote part of Texas. That's why they fled the state, because the sergeant at arms of the Texas House has no jurisdiction to go arrest or secure anybody in the state of Illinois. So what else is happening? The House, after 2021, also made a change to Rule 5, Section 3, and that says, if a member is absent without leave for the purpose of impeding the action of the House, and again, that clearly applies here, right? The Democrats have been very clear that they want to impede the action of the House. That member is subject to one or more of the following. And then it says fines, payment of costs, reprimand, censure, or expulsion. But again, remember, we read Article 3, Section 11 from the Texas Constitution. Expulsion requires 2/3, right? If they had 2/3, they wouldn't need to bother with the Democrats in the first place. So none of these Democrats are going to get expelled from the House by virtue of having walked out. But they are incurring these fines. And the fines, as we've said, are under Section E. It's in the amount of $500 for each calendar day of absence, and the member's pro rata share of the costs incurred by the sergeant at arms to secure their attendance. So that's really a good transition to the third question of, is this going to work in any long-term sense? Will this block the passage of HB4? Will it prevent Republicans from adding 5 extra Republican seats to the U.S. House of Representatives by redrawing their legislative districts to pack all the Democrats into just 8 seats? And the answer to that, I think, is no. No matter how long the Democrats stay out of the state of Texas, Governor Greg Abbott has an unlimited right to convene special sessions of the legislature. Those last for up to 30 days each. So this current legislative session was a special session. It was called on July 21st for the express purpose of giving Donald Trump what he demanded, those 5 congressional seats. It can last up to 30 days. The Democrats can run out the clock on that one, but if they do that, then Governor Abbott can just call for another one. And at some point, the rubber will hit the road, right? These fines are racking up. They're $500 per calendar day, which is a non-trivial amount for each and every one of these state legislators. They would rather, if they stay out a month, they would rather have that $15,000 for their reelection campaign than to have to pay to the state of Texas. And that, I think, really wraps up this entire discussion. Because look, if you had a situation where a minority could permanently prevent legislation from getting passed, cough, the U.S. Senate, right? Then that would truly be untenable, right? I don't want a situation. I would like for Democrats to become the majority in Texas. I don't want a situation where Democrats could block every law from getting passed in the state of Texas, right? Like, go out, win, persuade people, give them something to vote for. And that's why this quorum-breaking stunt, and it really is a stunt, is its own corrective motion, right? Because in order to avoid being hauled back in, probably in handcuffs by the sergeant at arms, and forced to report and forced to be there, to at least be present, to give them a quorum, In order to do that, you have to flee the jurisdiction. You have to leave the state of Texas. That looks bad to your constituent. However, in order to justify, hey, I represent the people of Laredo and I'm representing them from Chicago, Illinois, that's a tough sell. And so it's a natural political check on abusing this process. And it's backstrapped by the fact that these are part-time citizen legislators, right? These are not people who hold this job full-time. They're in many cases away from their families. They're incurring these penalties. So this is going to get broken. And Democrats have said that, right? They've said, we intend to use this as an opportunity to draw attention to this issue. And I hope they're successful in drawing attention to the issue. But the idea that anybody needs to be punished for this in any way whatsoever is, the kind of overblown rhetoric you would expect out of Texas Republicans. Okay. Be sure to let us know if you've got any further questions on what's happening. I'm sure everything will have changed by Friday's show, but that's the legal analysis of a supermajority quorum. There are 4 states that do it. Texas is one of them, and this is absolutely something that everybody could have anticipated, has been used in the past, is being used right now. And, I guess one last thing, I asked our elections expert, Joe Dye, how much Democrats might be able to retaliate by redrawing their maps in New York and Illinois. Both New York Governor Kathy Hochul and Illinois Governor J.B. Pritzker have said, if Republicans do this in Texas, we're going to have to fight back. And Joe says he thinks there are 4 seats across those 2 states, 1 in Illinois, 3 in New York, that Democrats could retaliate. So again, even if that happens, we're looking at a situation where Republicans have added 1 more seat to their total, not by being more popular, not by persuading independents, but by redistricting, which, thanks to the Roberts Court, they are now allowed to do for partisan gain. And I think that's terrible. That's on the long list of problems we need to solve once we get Trump out of office. Okay, that's going to do it for this segment, and we will be back after one more ad break for a little bit of an update on Alina Habba, unless, of course, you are a subscriber. Thank you so much. And we're back. Okay, this is a developing story about a case called U.S. versus Giraud, which is a criminal indictment alleging that a father and son, the Girauds, were engaged in drug dealing. And so there were drug crimes, gun crimes. That sounds a little far afield. The Girauds were indicted in the U.S. District Court for the District of New Jersey. So, as I said in the intro, this is really a case about Alina Habba and about the Trump administration's determined efforts to keep her illegally on the job as acting U.S. Attorney for New Jersey. And this case really foreshadows how Trump's insistence in keeping her on the job could potentially throw every criminal prosecution in the state of New Jersey into complete chaos. Just as a quick recap, U.S. Attorney might not strike you as an inherently political position, but it's been treated that way, right? Like Rudy Giuliani very famously catapulted from being the U.S. Attorney for the Southern District of New York into being mayor of the city of New York. And so as a custom, what that means is that U.S. attorneys will typically resign when the White House changes political parties. Even if there wasn't such a custom, the job of U.S. attorney is not like some of the executive branch appointees that we have talked about, where Trump has come in and fired executive branch appointees who were protected, right, who could not be fired but for cause. U.S. attorneys don't have that protection. They serve at the pleasure of the president. They can be terminated for any reason. They are not insulated. And so the former U.S. Attorney for New Jersey, Phil Selinger, resigned as Trump took office. And the law lets Donald Trump appoint an interim candidate to fill that role while he submits a permanent nominee to the Senate for confirmation through the advice and consent process, right? And so that interim candidate can be anybody that the president wants, even Alina Habba. And the check on the president appointing somebody as incompetent as Alina Habba is that those interim candidates are limited in how long they can serve. It's either 120 days or it is until a full-time candidate is confirmed by the Senate, whichever's shorter. 28 U.S.C. Section 546. Trump has used that interim process in New Jersey twice, because first, he installed a guy named John Giordano, a Virginia prosecutor who had worked on Trump's 2016 presidential transition team, so qualified for the role. He was there 3 weeks before being literally shipped off to Namibia, and then Trump said, I'm going to stick Alina Habba in there and also nominate her to fill the position on a permanent basis. Now, there is a 4-day discrepancy as to exactly when Alina Habba took office. It is being litigated in this Giraud case, right? So because Trump burped out on Truth Social, Alina Habba will be our interim U.S. attorney for the District of New Jersey, effective immediately. And he did that on March 24th, 2025. But now the DOJ is arguing that Habba's 120 days didn't begin for real until she was formally sworn in by the Attorney General, Pam Bondi, on March 28th. So there's a 4-day gap. That means that her term as interim U.S. attorney expired either on July 22nd at the earliest or July 26th at the latest. And I should add, at the same time, Trump waited 3 of Habba's 4 months as interim candidate before formally submitting her nomination to the Senate. It requires confirmation. There's no way the Senate was going to act on her nomination in 30 days. I thought there was no way that they would confirm her at all. But after the Senate signed off on Emil Bovee last week, I'm pretty sure that's an Andrew was wrong. Anyway, the interim U.S. attorney law does provide for how to continue to fill the office if the interim appointee's 120 days expires before a permanent nominee is confirmed. And that is Section 546D. It lets the district court appoint anyone they choose to serve until a nominee is confirmed. Anyone, for as long as it takes, right? So as we said on the show, most recently, episode 154, one such appointee, Guillermo Gil, served as interim U.S. attorney for more than 6 years across 2 different presidential administrations. So really, could have been anybody. Trump, A.G. Bondi, and Deputy Attorney General Todd Blanche all urged the court to appoint Habba on that basis. They said no. Instead, they picked her first deputy, a career prosecutor named Desiree Grace. And then we have talked about the rigmarole that Trump tried to engineer to get Habba back on the job back in episode 154. This is adjacent to that because this criminal case against the Girauds was initially signed to Judge Edward Keel in New Jersey. But on July 28th, he reassigned it to Chief Justice Matthew Brann of the Middle District of Pennsylvania to avoid any conflict of interest. It's still in New Jersey, right? Brann is sitting by assignment. But Keel said, because we are potentially involved, we, the judges of this court, are potentially involved in the question of whether Alina Habba's appointment is legal or not, I don't want there to be any question of impropriety. I don't want there to be any hint that we're doing something that is a conflict of interest. We're going to bring in an outside judge from the Middle District of Pennsylvania, unimpeachable credentials to handle this case, because this case is a challenge being brought by the Girauds that says, hey, our indictment should be thrown out. Now, first things first, the Girauds were indicted by the former U.S. Attorney Phil Selinger in November of 2024. So, spoiler alert, their indictment is not going to get thrown out. But the reason why it's not getting thrown out is, I think, really, really instructive. And the Girauds asked for 2 other forms of relief. They wanted Alina Habba disqualified from continuing to work her case. And they wanted to disqualify basically her entire office, right? Anybody who reports directly to Alina Habba, if Alina Habba is not legally on the job, everything she's done is void ab initio. She cannot supervise lawyers or get involved in the case. And what Judge Brann did was bifurcate those questions. He says, look, the doctrine of constitutional avoidance says that if this party, right, if the Girauds are not entitled to any relief, even if Alina Habba was illegally appointed, then I'm not going to decide whether she was constitutionally appointed or not, right? There's no point. If I can't make a difference in this case, I'm not going to try and resolve a constitutional question. So what he ordered the parties to do was, I want you to assume that Alina Habba was illegally appointed. If that's the case, then what remedies are you due? And the government refused to entertain that hypothetical. I've never seen that happen. Never, ever. They just filed a brief that said, no, Alina Habba was legally appointed. And Judge Brand was like, right, but I gave you the instruction. Right? Here's what he said. The government's argument to the contrary puts the cart before the horse. It argues that no remedy is available to the Girauds by simply rejecting the premise, which I ordered them to assume, that Ms. Habba had been illegally appointed. The government's position has extreme implications that it openly embraces. By using the special attorney designation and delegation, Ms. Habba may exercise all the powers of the U.S. attorney without being subject to any of the statutory limitations on that office. And so, Judge Brand ordered additional briefing, is going to take up the question of the legality of Alina Habba's appointment. And here's why. Because even though he declined to bounce the Giraud's indictment, he did so because the Girauds were indicted by Selinger, and there was no question of the legality of that indictment. And there is a ton of language in this first part of the opinion that says things like, Ms. Habba had nothing to do with the Giraud's indictment, nor has she engaged in their prosecution during the period in which her authority is questioned, except for the submission of a reply brief, a short motion in limine, and the instant briefing. So there has been essentially no ultra-virus action to invalidate. In sum, where an indictment was returned by a validly composed grand jury and signed by a properly appointed U.S. attorney, the illegal or unconstitutional appointment of a subsequent U.S. attorney does not necessarily require dismissal of the charges. And you see the negative implication. What happens to somebody that is indicted by Alina Habba's office tomorrow? They may have the ability to have that indictment thrown out. And so the Girauds don't get that. But on the question of whether to disqualify the office and whether to disqualify Habba, the judge says, yeah, if I find that she's not validly appointed, I can disqualify Habba, and there will have to be fact-finding on those who report to her and whether they have an additional avenue of authority. We're going to take a look at all of that, but the important thing here is this question is going to be teed up, and a district court judge is going to decide very soon whether Alina Habba can occupy the position of interim or special or assistant or whatever. She can continue to hold an office without being legally entitled to hold that office. And that's going to tee up yet another challenge. Okay, that is going to do it for us, for me, for today. I'm sorry to come to you without Liz. Obviously, we all wish her a speedy recovery, and we look forward to seeing everyone on Friday with the next episode of the show. And thank you so much, and thanks especially to those of you who are subscribers who support the show over on Patreon or on Substack. Couldn't do it without you. See you on Friday.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.